Welcome back to the second segment of this law session on contract law frustration. Now, before we went into the break earlier, I was dealing with circumstances where frustration occur. Well, we will just carry on in that same vein in this second segment. Now, the contract is alleged to have lost its commercial purpose, example, by the failure of an event upon which the contract is based. This is one way where you will find that there has been frustration, which of course will allow the parties to treat themselves as discharged from the contract. Now, there are two cases which are very important, and certainly if you are contemplating preparing frustration as a topic for the contract law exam, then Crellin Henry in 1903 and Herne Bay and Houghton in 1903 also are two cases which are important for you to be able to look at and draw the distinctions, because what you will find is that in the vast majority of cases where the examiner gives you a question, they will generally give you something with a little bit of factual scenario coming from both cases. So you need to watch that. If we look first at the Crellin Henry case, this was where the defendant had hired a flat on Pall Mall for the sole purpose of viewing King Edward VII's coronation procession. Now, the price that was agreed was £75 for 2 days. Now, the defendant paid £25 deposit, but due to the king's illness, the coronation was cancelled. Consequently, the defendant did not use the flat. The claimant sought to claim the outstanding £50. Now, the court said that the contract was frustrated as cancellation of the procession deprived it of its commercial purpose. Now, the claimant's action for breach of contract was therefore unsuccessful. However, the contract must be deprived of the whole commercial purpose to amount to frustration. And why I'm stressing it so much is that I want you to see the difference when we get to Herne Bay Steamboat and Houghton, also of course in 1903. The defendant hired out the claimant's steamship. Now, the purpose of the contract was the same again, was to take paying passengers to view the naval review, which was part of King Edward VII's coronation celebrations. Now, I want you to see the difference here, because the first one, they had hired this flat in order to get a good view, to be there, to be able to see the coronation, and the court said that it was frustrated. But here, what he wanted to do was, one, take paying passengers to view the naval review. The naval review was part of King Edward VII's coronation celebrations. The defendants were also offering the clients that they would have had a day's cruise for the passengers. Now, the naval review was cancelled again because of the king's illness. The defendant did not use the steamship, and the claimant brought an action for the agreed contract price. The defendant argued the contract had become frustrated due to the cancellation of the naval review. But the court said that the contract was not frustrated. They said the contract had not been deprived of its sole commercial purpose, as it was still possible to perform the day's cruise. They said the naval review was not the only commercial purpose of the contract. Now, again, you have to watch these in exams, because if you get something that's a frustration question, you tend to see where it is partly to do with one thing and partly to do with another. So you've got to consider whether the event that has occurred is sufficient to deprive the contract of its entire commercial purpose, because clearly we see Herne Bay saying that if there is some other commercial purpose, arguably it would not. Now, there is another instructive case in relation to the loss as it goes to commercial purpose. Of course, that is Nicola Knight and Ashton Eldridge and Company, and it's a 1901 case. Now, in the case, there was a contract between the parties, where it was agreed that a cargo of cottonseed was to be shipped from Egypt to England. The contract specified the ship, which was the Orlando, which was to carry the cargo. Now, this ship became damaged and was in for repairs when the contract was due to be performed. The court said, by naming the exact ship which was to carry the cargo, the contract was frustrated as it was impossible for this ship to carry the cargo within the contractually agreed period. Now, a contract may also be frustrated where it's deprived of its commercial purpose by government interference with strike at the root of the contract, and the case that this comes into focus with, of course, is Metropolitan Water Board and Dick Carr and Co. Now, Dick Carr, and it's Kerr. Now, Dick Carr agreed to build a reservoir in 6 years for the water board. Now, the contract said that Dick Carr and company should apply to the engineer for an extension of time in the event of delay whatsoever and howsoever occasioned. Now, Dick Carr were then required to stop work and sell their plant because of a government order. The House of Lords said that the contract was frustrated because the delay clause was intended to cover temporary difficulties and not such fundamental changes in the contract's nature. There is, of course, another case that you can look at, which also looks at that whole government situation in the context of frustration. It's a case called F.A. Tamplin and Anglo-Mexican in 1916. Delay is also one factor which may, of course, go to frustration. Cases on that, the NEMA and Jackson and Union Marine. Now, a lease may be frustrated, but only in very, very rare circumstances. And the case on point is National Carers and Panalpina, which we had mentioned before. Now, notwithstanding the principle that a contract may be frustrated in circumstances where it may be impossible to perform, there are, of course, limits to the doctrine of frustration. The fact is that the doctrine must be kept within narrow limits, and a contract will not be frustrated where, for example, it is more difficult or it has become expensive to perform. That will not allow for frustration. So difficulty, expense, which will make performance impossible, is not what the courts are considering here. Equally, where there is a force majeure clause, the courts will consider that the force majeure clause takes precedent. So where the frustrating event could be foreseen, we are seeing that frustration will not be applied. Now, if we start on the grounds of inconvenience or increase in expense, the case that I said that we would have come back to later and I raised earlier is the Davis Contractors Limited and Ferrum UDC in 1956. Now, the court said impracticality is not sufficient, and there is a subsequent case, the Sakiroglu case, which is also important, which shows this point. But let's look at Davis for a moment. Davis Contractors agreed to build 78 houses for Ferrum Council within 8 months, and the agreed price, of course, was £85,000. Well, due to a shortage in skilled labor and material, the contract took 22 months in order to be completed, and as such, it was much more expensive than they had anticipated. Davis Contractors were paid the contractually agreed price, but then they brought an action arguing that they needed more money based on the fact that the contract had become frustrated, and therefore they were entitled to further payment based on quantum merit. Now, the court said that the contract was not frustrated. The fact that a contract had become more difficult to perform or it was less than profitable is not sufficient to amount to frustration. It was still possible to perform the contract, and the court said that is what frustration is all about. Now, in the case of Sakiroglu and Nobly, the courts there looked at a situation where the defendant had agreed to ship some Sudanese peanuts during November or December 1956 to Hamburg, and there was a certain price set. Well, on the 2nd of November, the Suez Canal was closed to shipping. The defendant could still have transported the peanuts within the contractually agreed time, but this would mean them going via the Cape of Good Hope, which would have taken 4 times as long, and of course it would have meant that the cost of transport would have increased considerably. The defendant did not carry the goods and argued that the contract had been frustrated. Well, of course, the courts considered otherwise. The court said that the contract was not frustrated. It was still possible to perform the contract without any damage to the peanuts. The fact that it was more difficult or costly to perform is not sufficient to amount to frustration. Again, I would suggest that you look at the 2 cases that I mentioned earlier, Crellin Henry and Herne Bay Steamboat Company, because it goes to show you how far the courts will consider frustration and the limitations of the doctrine of frustration. We will break now again for a brief moment, and when we come back, we will carry on looking at the circumstances where the law will certainly permit the limits as to how far they will allow frustration to be used in respect of the principle.